All right. Good afternoon, officially, everyone. Welcome to week 11. This is week 11 of See You at the Closing Table, Contract to Closing Table Mastery for Florida Realtors. So many familiar faces in the room. For those who I have not had opportunity to meet before, I like to always make a formal introduction, not assume that you've ever met me before. So my name is Ray Cole Jackson. I'm a South Florida real estate attorney. A little bit about me personally. I am originally from Florida, Miami specifically. I attended the University of Florida. I always say go Gators. And then secondarily, I say go Canes. CJ in the room. I attended, she had her shirt on. I attended Santa Clara University School of Law for law school, where I was the founder of the Real Estate Law Society. Thereafter, I attended the UM Law School, where I obtained my LLM in real property development. I am a proud licensed realtor in Florida and Georgia. I forget this every time that I need to update this, but it's fine. We're in Florida. That's what matters. And loan officer in Florida and Georgia. For those of you who are just joining us today, we've been a long ways here. Today is session 11. We've been around this entire bend on various topics related to the contract to closing process. Today, we are discussing divorce, FIRPTA, death, and other special issues at closing that you guys should take into consideration. All right. Next week, we actually wrap up with the modern closing experience, where we're going to talk about just make sure everybody has clarity around the different signing options for in 2026, right? For your closings. I know that sometimes there's some confusion around the difference between online notary, mail away, e-signing, mobile notary. And so next week, we're going to have a conversation about that and how you guys should really look forward to deploying those different types of modern closing experiences to just create more efficiency and convenience for your clients, right? Like we always do, grab your handout, labhandout.com is our handout for today's discussion. All right. So, today's discussion, the pre-listing diagnostic playbook. Today, the goal of today's discussion is to help you guys identify underlying title issues that can delay your closings and sometimes prevent closings. They should not, well, they could prevent a particular closing, not forever, but it may prevent the closing that you were anticipating because that particular title issue was not identified early enough, right? So that's the goal for today. Now, I'll tell you, most closing problems, they don't begin at the closing table. Most closing problems do not begin at the closing table. They begin when an important question isn't asked early enough. So most of your biggest hurdles to closing, they were always there. They were there at the listing appointment. They simply were not uncovered, unfortunately, right? And so today's discussion is about uncovering potential closing issues early in your transaction process, right? So what we're going to discuss today, these are issues that could have been identified during the listing appointment. These are not issues that should have been identified once the property got to closing and was already under contract and the title commitment was ordered and received and back, right? So by the time we finish today's discussion, the goal will be for you to recognize hidden legal roadblocks before the contract is even signed. How am I queuing in on what potential issues are even during a listing appointment? Then what is my methodology for identifying these early issues? And then lastly, once I identify them, what is the result of that? What are the realistic expectations that I need to set for my customers? Who do I need to get involved in the transaction from now to ensure a successful closing? Many of the issues that we're going to discuss today, actually, all of the issues that we're going to discuss today, they require you get someone involved before you even go into contract. It is a misstep to wait until you go into contract to address these issues. It's in a you guys have heard the term before, friendly fire. This is an avoidable error, right? So the four main major issues we're going to discuss today is going to be death and probate, marital changes, specifically divorce. We're going to discuss FIRPTA, and we're going to discuss short sales. All of these issues they present during the listing appointment. Somehow, some way, they're not uncovered until the file gets to the closing agent, and as they say, all hell breaks loose, right? So, starting with death and probate, what are some of the conversational signals that you need to be hearing or you need to cue in on when you're having an appointment with a seller who is going to be impacted by death and probate in the closing process? They're starting to use the terminology, oh, I'm the executor, I'm the personal representative, I'm the PR. You're like, wait a minute, PR, what's going on here? I'm the only heir, I'm the beneficiary. Oh, we have a will. Why do you need a will? Why do we need a will? Who's not alive, right? Oh, we haven't started probate yet. Oh, we the estate. Who's not alive? That's the first thing you should be saying to yourself when you start hearing that terminology. Who is not alive? That we're having conversations about a will, probate, personal representatives, right? Um, I'm the only beneficiary. What's going on, right? We need to have more conversations around that. And so, because what ends up happening is the major question is who has the authority to sign the deed? That's what you need to know. So, hypothetical, you have um, four siblings. Let's say you have four sisters, and your client, the person that you're communicating with at the listing appointment, is saying, "Oh, I have the authority to sign." And your next question is, how many parties own the property? Who's on the deed? Why are we having a conversation about, you having the authority to sign? Was this property taken ownership received by death, or is someone deceased? And they say that, then you need to get someone involved. You need to start getting title involved specifically, the closing attorney, because what's going to end up happening is, I've mentioned this in previous sessions, you should do this on every file in general where you know that you're in the county where the seller is going to select the closing agent. But definitely in this case, that file needs to be sent in to the closing attorney so that title can be ran, so you can see what the examiner is going to ask for with regards to that file. Even if, for example, probate has been completed, guess what, guys? When probate is completed, the court, even though they may issue orders that allows the property to be sold, those orders are not automatically recorded in the public records. Title needs those orders recorded in the public records. Death certificates are not recorded from that probate. Orders are not recorded from that probate. All of those items have to be received by title and then recorded in the public records. And God forbid, we need certified copies, not just a copy from the client's, the copy that they got from the attorney when the probate happened. No, we need certified copies from the court. That means a copy specifically from the court that then can be recorded. With regards to the death certificate, we need a particular form of death certificate. It cannot have the individual's cause of death, right? So here we are. There's some work to be done. And this could take a small amount of time or it could take longer. Or what about, for example, and this happens, and you guys would be surprised how often this happens. There's a probate, okay, probate is successfully completed. One of the parties who obtained legal title to the property, now they pass away. There was no probate for that person. Deal is completely off track. So whenever there's conversations around who you start hearing this language, you need to immediately get that file into the closing attorney, make sure a title commitment is ran, and so that you can know what documents are going to be needed to resolve that, to get that property sold. Now, here's the other extreme. Uh, we have had files where we've had 22 heirs that need to sign. 22. Actually, was it 23, Rihanna? Might have been 23. Up until that point, I think my limit, I think my max was like 17. This one has 23. They took the cake. 23. Can you imagine how much time that's going to take to get 23 people to sign closing documents? That's a lot of time. And it's some money, right? And you want to know that. Can you imagine if you're the listing agent and I send you back the title commitment and I say, oh, congratulations, Peter. Yep. Well, we got title, but we need to go find these 23 people. You just want to throw your hands up, like, call me when you're ready. All right. But that's something that you should know. What if you were counting? I mean, counting, of course, you're counting on every closing. But what if that was a one closing? It was a big one, too. And you're like, yeah, it's going to close. But once these 23 people line up and sign, right? This is something that you can know ahead of time, right? So, what you should know is ownership does not equal authority to sell alone, right? And I love this graphic. I always love the iceberg because it is so indicative of what we often see up top is not inclusive of everything that's at the bottom, right? And so this is for you as a visual to let you know whereas you're like, oh, my mom passed away, I'm the only child. Okay, that's what we're seeing on the top, but at the bottom you're the only child, but has the probate been completed? Are all the required documents recorded, so on and so forth, right? So again, you want to listen for those red flags of, heirs and this person passed and my brothers, or you can even ask because this is a recent issue. Uh, you have so that the four siblings, you all inherited the property by virtue of the probate. Yes. Do you all agree to sell? And watch their facial expression. Do you all agree to sell the property? Because remember, you as a listing agent, you should have all owners on your listing agreement anyway. So that's the first step. You need to have all owners on your listing agreement because, and again, this is a hypothetical, but it is based on a true story, as we say. If you don't have all the parties who are owners on your listing agreement, and let's say you even go forward and you find a buyer, and then everyone doesn't sign the contract. The parties who didn't sign the contract, they're not bound to sell that property. There's four of us who own the property, and you only have the signature of three. I'm not selling. And again, as I said, it's a hypothetical for the purposes of today's conversation, but this is based on a true story. Guys, make sure when you have individuals who have inherited property, you want to make sure that they're all on the same page. You want to make sure that they all sign the listing agreement. You want to make sure that they all sign the contract so that you are clear that they all agree to sell the property. Because if all do not agree, you're not closing, right? At least not in the traditional manner. There could be some other legal matters that come on that. Said he had seven. Can't imagine any more than that. Yeah, seven times three plus. That was crazy. It was almost four times that. When I saw that title commitment, I was like, you gotta be kidding me. Not 23. What's the second big one? Divorce. Divorce. What are some of the conversation signals that you're hearing in your listening appointment? Oh, we're separated. Guys, in Florida, you're either single or married. See, a single married. That's it. And divorce, of course, means single. We don't have separated. We don't have common law marriage. We don't have any of that. It's either hot or cold, black or white, on or off, married or single, right? Separated doesn't work. Separated means it's complicated. And that's the last thing you want is a complicated transaction, right? The divorce is almost final. What do you mean the divorce is almost final? What's left? Right? The judge gave me the house. My ex moved years ago. Okay. When you start hearing those signals, you have better, you have better be asking additional questions, looking at public records, who is currently shown as the owner in public records. Because here's the reality, which you guys probably would not expect. Just because a judge issues a final judgment of divorce, that does not automatically convert ownership of the property to whoever was awarded the property in the final judgment. The final judgment is essentially instructions of what the parties are the next steps they're obligated to take, but the parties still need to go take that next step. If they don't sign the quitclaim deed or if they don't refinance the mortgage, then everything as it relates to that property remains status quo, right? That's what y'all got. You have to understand that everything remains status quo. That means that that ex-wife or ex-husband has to participate in that sale. They have to sign the deed. They have to sign the deed because they're still on title, right? Um, Now, of course, in most cases, yes, there are peaceful dissolutions of marriage, but in most cases, those dissolutions are what? Adversarial, right? And so when you are dealing with those situations, not only do you have to keep in mind the legal side of that divorce, now you have to keep in mind the emotional side of this divorce that's going to be involved in your contract to closing process. So what does that mean? That means pack your patience. That means get ready for a lot of arguments. That means get ready for hearing a whole lot of backstory before you get the answer to the one question that you asked, right? And you guys should be notifying the closing attorney. When you know about these things, let them know so they can prepare ahead of time, because literally we've had spouses, they don't want to be on the same email. Do not include me. They don't even want to be on the same email. Like they don't even want to be in the same virtual space with each other. Right? Like we need to know that, right? And you need to know that. So when you hear those types of conversations about we're separated, um, the judge awarded me the house, check public records. Who's still on title? If they are both still on title, they both need to be involved in any sale of that real estate. Period, point blank. Now, I want to add this because this conversation came up in office hours today. Um, right now, we're talking about the sale. This applies to purchase as well. There's no such thing as separated. In Florida, if an individual is married and they're purchasing real estate and they're taking title in their personal name, there's going to be an expectation that that spouse signs the mortgage. We are a homestead state, and that means that the spouse of any individual who has a homestead interest in the property, they must participate in signing documents related to that homestead property. They must participate in signing documents to acquire that homestead property. They must participate in signing documents to sell that homestead property. So with that being said, if we will flip to the other side of this and you're working with a buyer who is separated, going through a divorce, can they purchase? Sure, but there are some considerations. They need to have a conversation. First of all, they definitely need to speak with the divorce attorney to make sure that that property is not going to be considered community property because you purchased it during marriage. So I would say, just as a general matter, in most circumstances, if you have a buyer that's separated, they need to just wait. Wait until the divorce is final, because there's just too many moving parts with that property that they would have to dot their I's and cross their T's and document to ensure that that ex is not going to be involved. All right. Good question in the chat. What if the buyer's paying cash? Do they need to sign? No. And here's why not. Homestead is related to protection of the property from forced sale for enforcement of judgments. And so a mortgage allows the lender to force the sale of the property because you've agreed to that in that mortgage. That's why you must sign it. All right. So as it relates to a cash purchase, there's no mortgage on the property, so there's no need for the spouse to sign. All right. However, of course, on a sale, um, what if the spouse acquired the property before marriage? Does the now spouse need to sign that sale? Yes. You're married now. Exactly. Answer yes. Yes, you're married now. All right. Unless it's not homestead property. And you can't just say it's not homestead property. For you to affirm that it is not homestead property, you have to offer up to the closing attorney the address of the property that is your homestead property. And it's going to go on the deed that this is not my homestead property. This is my homestead property. This address is my homestead property. All right. All right. So, FIRPTA, particularly in South Florida, you guys have to be sure on this one. What are some signals? The seller lives outside the U.S. The seller indicates that they are not a U.S. taxpayer. The seller indicates they do not have a social security number. We're talking FIRPTA. FIRPTA stands for Foreign Investment in Real Property Tax Act. This is related to the seller specifically. She says not fair. This is related to the seller specifically, not the buyer not having a social security number, the seller not having a social security number or EIN number. This is important because when we apply FIRPTA to a transaction, it is up to 15% from the purchase price, not their net, the purchase price. So let's say, for example, the purchase price of the property is $500,000, but after closing costs, they only net 20. It doesn't matter. It needs to be 15% of the 500,000. And in that particular case, you're underwater, right? Because 15% of 500,000 is more than 20, right? So if you're having a conversation with a seller, and let's say, for example, some of the telltale ones are what? Owners from Canada, right? Oh, we're in Canada. Do you have a U.S. Social Security number or tax ID? Or do you, if they don't, do you already have a certificate of withholding from the IRS? That's where they've already gone to the IRS and confirmed what their tax withholding rate is going to be. If they do not have that, the closing agent on behalf of the buyer is going to facilitate withholding up to 15% of the purchase price and sending it to the IRS. Right? So your diagnostic question during a listing appointment for the purpose of checking off this this question is, could this seller be considered a foreign person for the purposes of FIRPTA? Are if they're saying things that indicate that they don't have a social security number? If so, you need to get early involvement of a CPA, because a CPA is going to have to prepare documents that are sent to the IRS. Now, the CPA can't get involved from the beginning and obtain a certificate of withholding, because the rule is within 60 days of closing, either that 15% needs to be sent in to the IRS, or the amount that the IRS has indicated to the seller that they need to send in. And that is effectuated by a certificate of withholding. The certificate of withholding says, here's the amount that you need to send from this sale. The closing agent is going to need one of the two. Now, if you represent a buyer, here's why this is important. The tax code penalizes the buyer if this amount is not withheld. Even though a CPA, an attorney, helps facilitate the withholding and the filing to the IRS, the tax code is written such that the buyer is responsible for the withholding. If it is not withheld, they are going to put a lien on the property that the buyer now owns. And it is pretty hefty.
Give me a roll.
right?
You said the amount is 15% of the sales price?
Yes. Yes. And of course, there's some exclusions, which I'm going to talk about now, such as if the buyer is willing to sign a FIRPTA affidavit saying that they're going to use the property as their person under 300,000, they're going to use the property as their personal residence for at least half of the upcoming 2 years. So at least 6 months of each of the upcoming 2 years, then the buyer can sign a FIRPTA affidavit, whereas the seller, the amount will not have to be withheld from the seller. So less than 300,000, buyer has to be an individual, cannot be an entity, because an entity does not have a personal residence, right? So how does this work? If you hear this, and some of you probably you know this and you're already doing this, in your listing, you're saying buyer must be willing to sign, must be able to sign a FIRPTA affidavit. Now that you all are familiar with this, you understand why that's in the MLS. That is triggering to you. This seller is subject to FIRPTA unless this affidavit is executed. The FIRPTA affidavit is executed. If the FIRPTA affidavit is executed, then the seller does not have to have that amount withheld. That means that if you are an entity, that means you can't sign this FIRPTA affidavit. That means the seller's not going to accept your offer. That's what that means. So for you as a listing agent, going back to the listing agent side, strategically, if you know your seller is subject to FIRPTA, but it can be exempt from FIRPTA withholding if you get a buyer who signed a FIRPTA affidavit, you're placing that what in the MLS. So again, you're heading this off versus getting to closing, which we've had it happen where seller is subject to FIRPTA. We send out a draft alta and they're like, what is this 15%? You're subject to FIRPTA. The buyer is not, the buyer's an entity. They can't sign a FIRPTA affidavit, right? There's no exemption here. And the seller was very upset and they got to hustling and working on a certificate of withholding, but they were not aware. And obviously the realtor was not aware as well. So we got to closing and then it presented itself, right? The fourth and final one is short sales. Um, this one shouldn't be missed. I mean, can it be missed? Sure, but it shouldn't be. What is a short sale? The short sale is when the property's value is lower than the amount owed to the lender, right? So property's worth 300, but the amount owed is 500,000. Ooh. So if you start hearing the seller say, I'm in foreclosure, ooh, I owe more than it's worth, or just the telltale, the bank has to approve. The bank has to approve. What's going on? Do you owe more on the property than it's worth? Yeah, you're in short sale territory. So the question is, will the sale proceeds pay off every mortgage and lien at closing? What does that mean? That means every mortgage. If you have two mortgages, it has to pay off both mortgages, right? Not just the first, not just the second, both, right? And then if it's a situation where you have multiple mortgages, your short sale negotiations now require both lenders accepting less than what they're owed. So what is the effect of that? What do you need to prepare for in a short sale situation? You need to prepare for longer timelines because now you have to facilitate either you or maybe a short sale negotiator or maybe the seller is handling it themselves. You have to facilitate lender negotiations for a short sale. If you've ever been involved in a short sale negotiation, it is a lot of just back and forth of documents, bank statements, pay stubs, hardship letters, um, what is this? What is that? Where's the HOA statement? Right? And you need to protect the buyer from frustration because this is going to take longer than a traditional closing. This is not going to take 30 days. This is not going to take 30 days. This is going to take you at a minimum, 60 days. because you're looking at about 45 to negotiate it. And then you're looking at, especially if the buyer is financed, you should not be getting into the buyer goes under contract. The buyer should not be getting into locking rates and all of that because you don't even know when you're closing yet. So what ends up happening is, and this is how your short sale rider is drafted, you don't really start the traditional closing process until you get the short sale approval. If you guys pay attention to your short sale rider, it specifically says that closing will be 30 days after short sale approval, 15 days, 20 days after short sale approval, right? Because that first amount of time is you negotiating a payoff, a payoff that's short of what the lender is owed. Unfortunately, guys, I can tell you, we, and someone asked me this before, in the last few months, we've had quite a good number of short sales. Had a good number of short sales. So you guys should know this process. We've had a good number of short sales. So here again, if you are working with a seller that is upside down, as we call it, on their value versus what they owe, you need to get that contract into the closing agent because as part of the short sale negotiation process, the seller's lender is going to want a title commitment. And then they're also going to want a draft settlement statement that only the closing agent can provide to them, where they're working the numbers up to see what they're willing to accept. What's going to end up happening, just to fast forward you guys a little bit, what's going to end up happening is at closing, the seller, the individual that you're working with, they're not going to get any cash out. They're not going to get any cash out. The way the settlement statement is going to look, it is going to allow for the lender is going to establish a purchase price based upon how much they're willing to accept short of what they're owed. So the settlement statement is going to show, all the closing costs and then what's left after the traditional closing costs, such as commissions, uh, title insurance, searches, so on and so forth. That number that's left, they're going to accept that as their payoff. So seller's going to get zero, zero, $0. You'll see it say due to seller, zero. Sometimes the lenders may negotiate some moving costs. Haven't seen that in a while. Right now they just want you to be happy that they're not taking you to foreclosure and getting a deficiency judgment, right? So what you need to know is if you have a seller that you know is underwater, know that again, the seller alone does not make that decision. You have to now get involved with the lender who is going to approve your ultimate sales price. All right. Um, and again, unfortunately, we've had files that have come in where the realtor was completely unaware. And again, you guys should not be in that place because what was one of the other pre-closing due diligence recommendations we made? Order a payoff statement.
Exactly.
Yeah, order a payoff statement. You get the payoff statement, and you're like, this thing says $500,000
Right.
worth 300. Mr. and Mrs. Seller, step
And
aside.
they're responsible for the closing costs on
Who's
top of that.
responsible? So that's a very good question. So you also get into situations where the seller's lender does not agree to um, cover traditional seller closing costs. So for example, in one recent closing, the bank didn't want to cover the estoppel. Like that's a standard seller cost, but they said they weren't paying it. So the buyer agreed to pay it. Um, so again, it depends on what the seller's lender will allow for. Um, they're usually pretty fair, but that was a unique one where they cut out I'd say about two or three traditional seller closing costs that they wouldn't allow. But the buyer picked them up because on the buy side, if you are the buyer and you do have the time to wait, in that particular case, I think that one took maybe about 6 months. But for a buyer and you do have the time to wait, guess what you know for sure? You know that you are getting that property at at market value and that's it, right? You're not. paying $1 more in general than what it's worth, right? Do VA loans have more leniency than regular loan for short sale? I wouldn't necessarily say they have more leniency. They're just more efficient, right? Because remember you the um what we call the servicer, right? So it all depends on who's servicing the loan. So the person who monitors and who manages that loan, they set the parameters around how long it takes for them to respond, how meticulous they are with the documentation that they're requesting. I mean, ultimately, they all are supposed to hit the same result, but it's just about how efficient each one is. All right. Um, the summation of these four different major underlying issues that you should be able to identify during your listing appointment. Um, what you're asking is who has the legal authority to sign, right? You're going to ask the individual that you're speaking with, and you're looking at the actual public records. Case in point, public record says the estate of, excuse me? They've already identified that someone is deceased. When you see that, that's a problem. You're in probate land, right? Who are you calling? Probate attorney, title attorney. Now, I also want to clarify here the difference between a probated attorney and a title attorney, because again, remember, the probate attorney, they're just dealing with the court. The title attorney is dealing with the public record, which must be updated to reflect ownership properly for the purpose of sale. Does that make sense? So it's not just the probate attorney who can fix this. The title attorney needs to be involved as well, because the title attorney is going to go back to the probate attorney and say, we need the certified copy of this order. We need the death certificate. We need all these items to now be in the public records, recorded properly, so that chain of title is updated, right? With regards to divorce, who's on record title? Again, you're still going back looking at public records. If you still see Jane Doe and John Doe, even though they're now divorced, well, they're both still on title. So they both need to be involved in this closing. So we're getting the closing attorney involved. Potentially, you're getting the divorce attorney involved if the parties are not cooperating um, with the final judgment of divorce. The handout is at the link. The handout will not have the entire presentation. It has a summation of the discussion today, guys, for those of you that are looking for it. FIRPTA, are they foreign for the purposes of taxes? Not foreign as in, are you from Guatemala? No, right? Do you have a tax ID, social security number? If they do not, you're getting a CPA involved, and then of course the closing attorney to make sure that they're going to have what they need. And then short sale, will proceeds clear all liens? If not, got to get the lender involved, got to get the closing attorney involved, right? Again, ask questions. So we're not, so from today's discussion, we see that, and someone's mind is like, Rico, you are just adding to all the things that I have to talk about. So from today's discussion, you're finding out that in that listing appointment, you're not just talking numbers. You're not just talking value. You're also talking legal status of that property, right? Do we have clear title? Is this purchase ready? Is this purchase ready? Is probate completed? Right? Is the divorce, is all documentation executed pursuant to the divorce judgment? Right? Is the seller aware that they're going to be subject to FIRPTA? And so they've already reached out to a CPA to begin requesting a certificate of withholding, or they're prepared to accept 15% of the sales price being withheld at closing, and then they go work with the IRS thereafter, because that's how they get the difference back. The seller is then going to have to communicate with the IRS to get the difference back, right? And then, of course, short sale, that does go to value, but how does it involve legally? You can't just unilaterally make the decision to accept 300,000 when you owe 500. Legally, to get clear title, we need to get the lender involved, right? So that's what we're learning today, that at that listing appointment, guys, it's not just numbers. It's not just dollars and cents. It's also, is this property purchase ready from a title and legal standpoint? So you now know the underlying 4 traps that you should be queuing in on. The objective is to spot verbal cues based upon what they're saying. And then the lab approach is to use a structured workflow. Now that you know that these items are an issue, what's my handoff? Right? What's my handoff? Because your role is not to resolve it. That's not your thing. Your responsibility is to have a disciplined workflow where you know what your listing presentation should cover, right? It's almost like it's a diagnostic. That's why we describe the training today as a diagnostic. We're making sure we check all the boxes. Listening for conversational signals, right? Deploying those questions in your diagnostic, and then immediately, there's no need to wait. Immediately activate the professional that needs to address the issue. Why wait till you go under contract? You guys see me like holding my head because like you didn't know this. Like this literally is still how. Why? Why wait until you only have 21 days to resolve it? When we could have been working on this 30 days ago, right? So it just based on today's discussion, you don't need to necessarily know more about this from a legal knowledge standpoint. You just now need to make sure that it's included in your workflow and you're disciplined about identifying these issues. All right. So know your boundaries. Don't try to give legal advice. Some of you probably dealt with some of these items before, particularly maybe FIRPTA, and you've probably consumed my conversation about FIRPTA well enough that you can regurgitate it, but you're not a CPA, and don't even blur those lines. Direct them to a CPA to get further questions answered, right? You might have dealt with enough probate, probably maybe even in your personal life, that you feel like you can answer questions on it. But let's not blur the lines. You're the realtor. You deal with the real estate. As it relates to the legal issue, you're going to get that in front of the probate attorney. You're going to get it in front of the closing attorney, right? So by staying in your lane, you not only protect the client from frustrations that's the potentially giving the wrong advice, you also protect yourself, right? You guys have enough to do. You have enough to do. You don't want them to keep folding you into issues that you cannot resolve. All right. So what's next steps? Next step is, of course, to update your intake, update your listing presentation, add those questions directly into your standard consultation questionnaire. Just ask them, right? Because of course, part of your preparation, you all go to the public records anyway, right? As soon as you see a state of, you know you're having a conversation about probate. As soon as you go to public records, you see Jane Doe and John Doe, and only Jane Doe presents. Where's John Doe? Right? You having a conversation about the net, and they're saying, "Ooh, well, we're a little bit tight on that." You know, the lenders they want too much for this house anyway. You know, wait a minute, wait a minute, wait a minute. We need to get a payoff statement because market value is about 300 and you're saying you owe 500, right? FIRPTA, same thing. Do we need to and you can even say, are there any FIRPTA considerations? And most people will say, what is FIRPTA? Those who are I would say 99% of sellers who are impacted by FIRPTA, they know and they've heard of it before. So you would say, do we have to take into consideration anything concerning FIRPTA when we put the property on the market? And if they say, what is that? You explain to it. Foreign Investment and Real Property Tax Act. The IRS requires that any individual who sells real estate that's reported to the IRS using their social security number or tax ID. Do you have a U.S. social security number or tax ID? If they say no, you're in FIRPTA land. If they say yes, you fine. You move on. All right. And then, of course, if they answer yes to any of these four questions, you identify that your transaction is going to have these four elements involved in any one of these four. You need to communicate early. Again, get the professionals involved. You've done your part. You've identified the issue. Now you need to hand it off to the professional that can help you with resolving it. So by doing this, of course, what you're going to protect the timeline, because everything that we've discussed here, it adds more time to your closing timeline. Undoubtedly, it adds more time. So, but if you identify it early, it's going to protect the timeline and it's going to elevate the experience. Your client is going to feel much better hearing it from you in advance before, rather than hearing it, you've already gone under contract. They're excited. They think they're closing on the 15th, and no, you're not, because we have some documents that we need to get from the court, or you have 22 other people that need to sign, or you don't have enough proceeds to send 15% to the IRS, or you actually owe more on this property than you're going to net. You're not going to be able to make the payoff, right? So these are things that we can do in advance to get ahead of these surprises, right? All right. Any questions? Let me see what's in the chat. Let's see. What happens when the title company find more did not sign a contract, but it's on a deed under contract? That's a good question. So Alexandra says, what happens if the title company identifies that an additional seller should be signing the deed? Yes, best course of action is to prepare an addendum to add them to the contract. Now, can the closing agent just continue on and close with preparing documents? Yes, but for your purposes, as both the listing agent and the buyer's agent, you want them bound to that transaction. The closing agent updating their records to prepare documents for that person to sign, that covers them, but that does not bind that individual to sell the property. So that is a very good question, and absolutely yes. You want them added to the contract so they are bound to participate in that transaction. Very good question. Very good question. Will it be best to tell potential clients to ensure that we have review a divorce decree or probate document? The fee to do so, if we're the closing agent, then that's included in closing. And yes, we would do that. The way we would facilitate that, again, the property would come in, we would run a title search, and that title search would examine all of those documents that are in the public records. If it's a probate, then we're reviewing probate documents. If it's a divorce, then we're reviewing the final judgment decree. All right, so that's a very good question. Did I miss anything? If someone was advised that they're going to be foreclosed on in the middle of the home being on the market, what should be done? Oh, that's a good question. So the first thing you need to do is you need to file a motion to stay, right? In the legal action. So two things you have to do. You need to stop the foreclosure from proceeding. And then you, of course, need to proceed with the sale. Now, I'll say this, I've mentioned this before. Just because someone is in foreclosure does not mean that they do not have enough equity in the property. I've said this before, and I'm glad you brought that up, Emily. We've closed a couple transactions this year. They were in foreclosure for various reasons. I don't know. But they left the closing table with a check. Just because an individual is in foreclosure does not mean that they are underwater. So, yes, there's two course of actions that need to take place simultaneously. You need to stop the legal action from proceeding as you continue down the path of closing. Very good question, Emily. And that's one of the topics that we're going to discuss next quarter with our listing lab theme. What if the found seller refuses to sign the deal? Is the deal dead? Okay, short answer, maybe. Here's why. For the sellers that did sign, there is potentially a legal action that can be taken against them for signing a contract that they cannot perform. Number one. Number two, separate from that, there is a legal action that those two individuals can file against that third to sell the property. It's called a partition action or forced sale. So what it says is essentially, I want to sell this property. They don't want to sell it. Court force them to participate in selling this property, and the courts will do that. So the short answer is the deal dead? Technically, no. There are remedies, but it's going to take time. And that's what our training is about today, to make sure that you don't run into these hurdles that delay what you thought was going to be a smooth closing. So that's a very good question, Kathy. And you guys let me know if you need any clarification on that. All right. I think we did it. Any other questions? And feel free to come off chat or raise your hand. I mean, come off mute and raise your hand if you do, if you don't feel like you can get it typed out quick enough. While we're wrapping up, reminder, we do have our office hours every day at 10:30. This is your opportunity to really kind of ask your questions in a casual environment, not have to, do it under the time constraints of lecture and then get your questions in the last few minutes of our training. So every day from 10:30 to 11, we are in office hours. So 1 second, let me see. Candace sent the question. Mm, that's a good question. Question is, what if a person is terminally ill? What is their best course of action um, to protect their ability to, I'm going to say, I guess you want to make sure that they can sell the property. Number one, if you are absolutely sure that they are terminal, you can have that person sign what's called a life estate deed, where they will continue to have, and I mean, again, anything can happen. They could miraculously turn around and live. But if they execute a life estate deed, then ownership of the property remains with them. In the event they pass away, then ownership automatically transferred to whomever they want to own the property upon their passing. This is important to keep in mind because, guys, a will alone still has to be probated. So that's what we talked about earlier. If someone says, I have a will, great, that's instructions. Now those instructions have to be followed by the court, right? So that's an important concept to understand, which I think a lot of people miss. Just because you have a will, that's just legal instructions that the court and your family members have to follow. That does not automatically transfer assets into the individual's names who are named in the will. All right. So that's a very good question. Not, and I want to make sure I say this too, not a power of attorney. Do not say, oh, we'll just get a power of attorney because she's sick. Well, upon death, power of attorney is no longer enforceable. You can't use it. Power of attorney does not survive death. So just getting a power of attorney signed because someone is sick, that's not what you want to do. No, you want to get the assets out of their name before they pass, because if they pass and it's still in their name and there's no life estate deed, there's no joint tenants with right of survivorship, there's no automatic transfer provision, you're going to probate. Okay.
What if they have a ladybird deed?
A ladybird deed is automatic transfer.
Okay.
Yeah, that is the automatic transfer mechanism.
What's a ladybird deed?
A ladybird deed is a common name for a life estate deed. Life estate is when you own the property during life, and then you have what we call a remainder man. Your interest in the property, when you pass away, automatically transfers to your remainder man. So it's called a ladybird deed. I think her name was Ladybird, First Lady, Ladybird Johnson, Lyndon B. Yeah, Lyndon Johnson's wife. So it's just a common name for a life estate deed. You call it a ladybird deed. You call it a life estate deed, right? Sick parent, there's no estate plan in place. Yep. I'll send you her information, Lorraine. Any other questions? Any other questions?
I have a question. I have a client that
Yeah.
I took a listing to sell his house, but recently the wife had a stroke and she passed away. So my question is, which I think I know the answer to it, but I just want to make sure. So if we do get a contract on the property, so the husband would just need to provide a death certificate, right, to show that the wife passed away, right?
The answer is you are going to send the file in for, well, it depends. So where it's due diligence now. That's the short answer. not waiting until you go into contract. Remember, that's what the training is about. So, is it in a county where the seller is likely going to select the closing agent?
Yeah, if it's going to be here in well, let's see in Broward County. I guess not.
Broward County, no, it won't be. That's not where they're likely to. However, um, you can. What I would recommend, so is you can send it in. We'd open it. We'll do a search, and I would say to you, if it does identify issues that are going to require extensive title curative, then you should in your listing say the recommended title agent is title experts, because we would already start working on that. Of course, the buyer can determine that they want to proceed and work with another closing agent, but you would have done your due diligence, which is that's the whole purpose of the training. Get
Okay.
ahead of it. You already know that there's death, right?
Yes.
You want to get ahead of it, and you don't want to make the determination on your own. So one of the first things we would do when you send it in, we're going to go to the public records. Who does this show is the owner of the property? We're going to look at the vesting deed. Does it show Jane Doe and John Doe as husband and wife? Then upon death, that is a trigger for title to transfer automatically to the wife. The only thing that would, I'm sorry, to the husband. The only thing that will need to happen is a death certificate needs to be recorded. For you guys' knowledge, husband and wife is the same as having language that says joint tenants with right of survivorship. Jane Doe and John Doe as husband and wife is the same thing as Jane Doe and John Doe as joint tenants with right of survivorship. It's simply that we use joint tenants with right of survivorship when there's not a husband and wife relationship. Or let's say, for example, you have like a file we have in the office, you have a husband and wife that also has a daughter going to be on title. You want to put all three of them and you want to include the language as joint tenants with right of survivorship, which creates a right of survivorship relationship amongst all three of them, not just the husband and wife. Right? So, short answer to your question, send the address. Jocelyn will look it up and see what title shows, and if it does look like you need to get a title commitment, pull a title commitment. If it's something that you need to start working on, you start working on it.
Yeah,
And
because
then
she just passed away about 2 weeks ago. They're in the process to getting the funeral and stuff like that. So
yeah. So email the address. We'll take a look at it and let you know what needs to happen.
okay.
And I'm glad you asked. That is prime example, guys. He heard death. He heard death. Get it in front of the closing attorney immediately. You don't want to wait until you go into contract to start cleaning it up. You want to do it now. You hear death. You hear probate. You hear I owe more than it's worth. You hear I don't have a social security number or a tax ID, right? Don't wait. Don't wait until you go into contract. Get it in front of the closing attorney immediately. All right. All right, this was good. If you guys do not already have the calendar of events on your calendar, the QR code will allow you to automatically sync all of our events to your calendar. You don't have to worry about missing an event. It includes the office hours, it includes the Thursday trainings, it includes any other training that is added to the calendar. So you just hit that QR code. Um, Also, the recordings are on our YouTube page. Feel free to subscribe to the YouTube page. You'll be notified via both the email that goes out on Friday, as well as if you subscribe, then you obviously get a notification on YouTube when a new video is uploaded. Um, old child support issues can become an issue. Absolutely, yes. Yes. Unpaid child support is an issue. Absolutely, yes. Yep. Here you go. So again, I'm glad you asked that question, Idiani. Listen, when you guys take a listen, and this is what we're going to talk about next quarter. We're going to really dig more into the pre-listing due diligence. When you take a listing, send the file in to the closing attorney. Let them order title. Let them start addressing title issues from the get-go. Why wait until you go into contract? Give yourself as much time as possible to address those issues, because absolutely, yes, child support is, if unpaid child support is a lien on the property and it must be paid. And you want that seller to begin taking that calculation into consideration from now. right? And so the conversation today, last thing I'll say, the conversation today is an opportunity for you to, those are common high-level diagnostics. But as a general matter, by virtue of your membership in Purchase Ready Lab, you have the ability, as soon as you go under contract, as soon as you sign a listing agreement, send the property in, start clearing title. Why wait until you go under contract? And now you're scrambling, right? All
Question.
right. Yeah, I had no idea. Yeah, because Marissa, because I owe you a phone call, huh? Woo! All right. Fees related to pulling title reports and doing the findings up front. Sure, we'll talk about that. We'll talk about that in the next quarter as we've talked about it during this one, but we'll talk about it more this because we're about 2 minutes over our time. All right. But I'm glad you asked that. All right. Let's see. One last question. If it was a single dad seller who raised his son, all of that's family law, Idiani. If it's recorded against the property, you have to assume that the judge found it to be a valid claim. They issued a judgment, so the judgment recorded against the property. Does that make sense? So all the details as to how there became an order of child support payment, that was resolved by a family court judge. When they issued that judgment, it recorded against any property owned by the person who the judgment is against. When it's time to sell that property, that judgment has to be addressed. All right. All very good questions. All right, guys, if you have any other questions, see us in the morning during office hours. We're on there from 10:30 to 11. Again, you're up at 2:30 in the morning, you have a thought. Again, that's what office hours is for. She said this was good. Good to see you,
Call you at
Cynthia.
2:30 in the morning?
I said, you said who works at 2:30 in the morning?
No, I said call you at 2:30 in the
No,
morning?
no, no. I said you hold that and you see me at 10:30 a.m. I said the
Oh,
thought comes
oh,
to you at 2:30. Again,
okay.
that's what office hours is for. I get a lot of text messages, random phone calls, like 10:30 to 11. Find me right here on labofficehours.com. Ask all your questions, right? Ask away any topic, and then go sell some homes. All right. All right, guys. Good to see you, Ediani. All right, guys. Marissa, I'll call you shortly, okay? Bye,
Got
y'all.
it.
Have a
Good to
Bye.
good
see you,
day.
Miss Jones. Bye, y'all.